We'll hear argument next in Students for Fair Admissions versus the University of North Carolina. Ms. Lewis, I'd like to start by asking you two questions. Does the 14th Amendment prohibit race-based affirmative action? And how does contemporary legislation in the 1860s and 70s affect your answer?
Yes, the Equal Protection Clause of the 14th Amendment prohibits race-conscious affirmative action. There is no indication that race-conscious action is permitted in the text of the Equal Protection Clause. Instead, the clause prohibits race-conscious government action. I understand that respondents argue that contemporaneous legislation, such as the Civil Rights Act of 1866 or the Freedmen's Bureau Act, were race-conscious, and that therefore the 14th Amendment does not prohibit race-conscious affirmative action. However, the respondent's argument is misplaced for two reasons. First, contemporaneous legislation is not always historically consistent with the Bill of Rights. For example, the Alien and Sedition Acts were inconsistent with the First Amendment, ratified only 9 years earlier. Second, the contemporaneous legislation relied upon by respondents is not race-conscious. To start, the long title of the Civil Rights Act of 1866 indicates the statute protected, quote, all persons, and was not limited to protecting certain racial groups or persons. Similarly, the legislation creating the Freedmen's Bureau was not particularly race-based because it focused more than just on Black citizens. The Freedmen's Bureau Act was, quote, an act to establish a bureau of relief for freedmen and refugees, including displaced Southerners.
That the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument work 150 years later in a very different society?
The framers of the 14th Amendment, even if concluding that race-conscious legislation was constitutional in the 1860s and 1870s, would not make this argument 150 years later. Congress's explanation as to why race-conscious legislation was appropriate would be remedial. That is, to provide remedy and correct previous harms done to Blacks in this case. The 14th Amendment itself was simply enacted to correct the problems arisen from the Civil War, race being just only one of those problems. For example, Section 3 of the 14th Amendment limits the ability of rebels, such as former Confederates, to serve in government. Section 2 and 4 address the misdistribution of representation and the debts of the states, respectively. Because of this context, the 14th Amendment was effected to remedy the harms done specifically to former slaves after the Civil War. In a different society, remedy is unneeded because of the relative equality in test scores, opportunities, and rankings. However, Section 5 of the 14th Amendment granted the authority to Congress to enforce the clauses of the 14th Amendment through, quote, appropriate legislation, end quote. Congress has already exercised their power in Title VI of the Civil Rights Act of 1964, which explains that, quote, no person, end quote, on the, quote, grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, end quote. Congress, with the authority to enforce the 14th Amendment, has already rejected the concept of race consciousness and opted for race neutrality in a different society. Here, the petitioners are denied the benefits of higher education because the University of North Carolina admits students on the grounds of race. As a public school, the university receives federal financial assistance and is subject to the Civil Rights Act. The university therefore directly violates the Equal Protection Clause because of its race-conscious admissions policies. Therefore, the argument posed in the question cannot work 150 years later to correct previous wrongs.
Let's assume that the framers of the 14th Amendment thought that people of African American descent deserved certain race-conscious privileges because of the special context of slavery. Would the framers have thought that people of other races, such as Hispanics, Asians, and Native Americans, also deserved special privileges.
If the framers of the 14th Amendment had thought that people of African descent or African Americans deserved race-conscious privileges due to the unique context of slavery, they would not have thought that then other races, such as Hispanics, Asians, or Native Americans, could receive similar privileges. In other words, the framers would not have approved of race-conscious remedies for minority groups who have not been enslaved. In this case, however, the University of North Carolina grants privileges to more than just previous slaves or those affected by slavery. It defines underrepresented minorities as African Americans, Hispanics, and Native Americans. As the university's racial discrimination extends far beyond those affected by slavery, UNC's admissions policies would be inconsistent with the hypothesis that the framers of the 14th Amendment believe that people of African descent deserved race-conscious privileges due to the unique context of slavery.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefited people on the basis of sexual orientation or gender identity?
The framers of the 14th Amendment would not have thought that affirmative action policies should benefit people on the basis of sexual orientation or gender identity, because they did not think about such identity. Moreover, affirmative action policies based on sexual orientation or gender identity were inconsistent with the purpose of the 14th Amendment. As I previously discussed in the answer to question 3, the purpose of the 14th Amendment was to correct the harm done by the Civil War. The 14th Amendment was not, however, an effort by the framers to create equality on all bases, such as sexual orientation or gender identity. Therefore, the framers of the 14th Amendment would not have thought about affirmative action to benefit people on the basis of sexual orientation or gender identity, because the purpose of the 14th Amendment was to correct the harm done by the Civil War.
Does Brown v. Board of Education prohibit race-based affirmative action? In your answer, please address Bakke and Grutter.
Brown v. Board of Education and a line of desegregation cases did not explicitly address race-conscious affirmative action. However, Brown implicitly disapproved of race-conscious affirmative action and addressed the purpose of the 14th Amendment, explaining how segregation was, quote, a denial of equal protection of laws, end quote, and explaining how equal protection was the vital point in that clause. 24 years later, writing for a fractured court, Justice Powell explained Brown's perspective on race-conscious affirmative action as allowable in the context where the purpose is to, quote, address the disabling effects of identified discrimination. Justice Powell explained that race-conscious affirmative action was allowable to correct proven previous discrimination. However, Powell drew a line distinguishing between previous discrimination and a more generic societal discrimination, which he described as, quote, an amorphous concept that may be ageless in its reach into the past, end quote. Justice Powell and Bakke identified two different types of discrimination, one being addressed by affirmative action and one that cannot be addressed. In Grutter, however, this court, agreeing with Justice Powell about Brown, held that there was a compelling interest simply in maintaining a diverse student body without needed proof of previous wrongdoings. That decision is inconsistent with history and precedent such as Brown, Bakke, parents involved, Bob Jones, and should therefore be overruled, as it places no standards on affirmative action. In other words, a diverse student body is not a compelling government interest. And even if it is, race-based admission policies are not narrowly tailored to further that interest.
In 2003, Grutter observed that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved by the Grutter Court. Will there ever be a time when racial preferences are no longer needed? If not, should the court allow racial preferences to go on for forever?
In 2003, when Justice O'Connor, approving of Justice Powell's previous dicta, said that this court expected that 25 years from now, quote, racial preferences will no longer be necessary, end quote, to further the interest in student body diversity? That time frame was given for a reason. This court's dicta had a factual basis in Grutter, citing how test scores and grades of minority students had already increased. To answer the first question, based off of Grutter, racial preferences will no longer be needed to be used in higher education when the test scores and grades of minority students is roughly equal. Moreover, racial bias is already forbidden in most circumstances, including housing, workplaces, and voting. Therefore, Grutter was already an exception, and now racial preferences are no longer needed because the ills of de jure racial discrimination have been addressed in higher education. To answer the second question, this court should not follow the Grutter court's dicta or allow racial preferences to go on forever because Section 5 of the 14th Amendment, an execution clause, authorizes Congress to enforce the Equal Protection Clause, not this court. Here, Congress has not legislated the use of affirmative action in higher education to achieve greater student body diversity. This court should not usurp Congress's authority.
Should Grutter v. Bollinger be overruled? Please discuss the court's application of stare decisis in the recent Dobbs decision.
Grutter v. Bollinger, as discussed in our brief, should be overruled because the governmental interest in achieving a diverse student body is not compelling, and any race-conscious admissions policy is inherently not narrowly tailored to achieve a diverse student body. Furthermore, Grutter should still be overruled because the doctrine of stare decisis does not protect Grutter. Grutter's framework with a focus on achieving a diverse student body is neither workable nor does it establish a sufficient reliance interest. To begin, this court in Dobbs explained that past precedents are workable if they establish a standard that can, quote, be understood and applied in a consistent and predictable manner, end quote. This court in Dobbs additionally defined that a reliance interest exists, quote, where advanced planning of great precision is most obviously a necessity, end quote. Here, Grutter is neither workable nor has established a sufficient reliance interest. Grutter is not workable because the Grutter court established no standard on how diverse a student body should be, how much of a plus factor is reasonable, or the line distinguishing good from bad intent. Universities are continually left to their own devices to define Grutter's insufficient standards because universities cannot understand or apply that framework in a consistent and predictable manner. Moreover, Grutter does not establish a sufficient reliance interest where advanced planning of great precision is necessary, because race in admissions policies is just one of many factors. Grutter's holding that race can only be considered as a, quote, plus factor means that its overruling, which would remove just one of many factors, will not require advanced planning by universities or students. Therefore, the doctrine of stare decisis, as applied in Dobbs, does not protect Grutter from being overruled because its framework is neither workable nor creates a sufficient reliance interest.
If the court declines to overrule Grutter, can your clients, Ms. Lewis, still prevail?
If this court declines to overrule Grutter, the plaintiff should still prevail because UNC's admissions policies are not narrowly tailored. US v. Playboy explained that narrow tailoring must demonstrate the least restrictive alternative, and, quote, if a less restrictive alternative would serve the government's purpose, the legislature must use that alternative, end quote. Moreover, in tailoring the use of race in admissions, if a race-neutral alternative can achieve racial diversity, the university should use that alternative. Here, UNC's use of race in admissions is not the least restrictive method of achieving a diverse student body, because UNC could use other race-neutral alternatives that have worked for other universities. One example of this is the University of Texas at Austin, which used the 6% policy instead. The 6% policy established that the top 6% of any high school is automatically accepted into the university. This can achieve diversity because there are schools with primarily one race or socioeconomic status. The University of Texas at Austin is therefore capable of achieving a diverse student body without using race in its admissions. UNC, however, is less successful and takes race into account. Their admissions policies are therefore not narrowly tailored to achieve a diverse student body because less restrictive means can be used.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
No. If this court overrules Grutter, the military will not have difficulty recruiting a diverse armed service. The holding in Grutter applies to the governmental interest in a diverse student body, while the military is not a school or a college. Therefore, Grutter's ruling does not apply. In short, this court's ruling in Grutter is irrelevant to the military's ability to achieve a diverse armed service because the ruling neither helps nor hinders military recruitment. Respondents argue that the military, with a less diverse selection of minority college students, will have difficulty recruiting a diverse armed service. However, the compelling interest relied upon by UNC is not in maintaining a diverse officer corps, but an interest in maintaining a diverse student body. Even if the university's interest was in maintaining a diverse officer corps, their admissions policy is still not narrowly tailored to further that interest, because their policies grant additional points to Black and Hispanic students without regards to whether or not students join the officer corps after graduation.